request, please connect me on LinkedIn. Okay.
Sir, I think we are ready to start. I'll start now.
Yeah, sure, sure.
Okay. Yeah. So good morning, everyone. Thank you for joining us today. I am Simran, and I will be the moderator for today's webinar. As the panelist of this webinar, at JustVocate Law Journal is proud to welcome Mr. Rahul Tiwari. Advocate Rahul Tiwari completed his legal education from New Law College, Bharatiya Vidyapeeth, Pune. He has also obtained his LLM specializing in cybercrime and economic offense. He has a strong passion for legal research and public speaking. He is a founding and managing partner of LNS Associate, and which is a MCA registered law firm. He has taught around 1,061 students on criminal law through certificate course. He has also been invited as judge for various debate competitions, national moot competition, and bail application competition by various prestigious universities. He has also presented many research papers in various international and national seminars. Thank you for joining us today, sir. Also, before we start the session, if anyone has any questions during the discussion, I would request you to put them in the chat box and they will be resolved. Moreover, there will also be an open forum for questions after the seminar. Thank you. The floor is all yours, sir.
Yes. Okay. So yes, hello everyone, and this is my 48th webinar, and the same introduction. I've been hearing this for like 48th time that I've done this and done that. So I mean, most of the time, especially when I'm invited by the moot court competition by various universities, like I've been invited by like close to 15 universities to judge their competition, which includes one competition from HPNLU Shimla also, and recently by UPS Dehradun. I just told them to please skip the introduction. Just skip the introduction, okay? It's it goes over to my head. So before we start, I'm extremely sorry for my sore throat actually. So before we start, can you guys give me a few examples that on which part we face a lot of false criminal cases being registered nowadays? Like, I'm a criminal lawyer and I have practiced in court for like now close to 2 years and also 1 year of serious internship. So can you please give me some examples, like in which under which sections, which are the sections in the IPC which are highly misused for filing the false FIR? Please raise hand and unmute yourself and answer. Can they raise hand, Simran?
Sir, I'm not sure if they can. They can put in the chat box though.
Yeah, they can put in the chat box, or if they want to unmute, they can unmute and can obviously give their answers. And let's make this, because we have like less number of participants, so we can make this webinar very interactive in nature. Okay, interactive. So please just tell me, like, which are the cases which are highly misused? Come on, give it a try. अरे मतलब फॉल्स केस होते ही नहीं इंडिया में, सब चंगा सी. Kavya Bhatnagar has joined. Rape charges, dowry cases, Shreya Srivastava has said domestic violence. Yes, yes, domestic violence cases are filed. Amrita Mohanty, very rightfully, dowry cases and also rape cases. Soumya Pandey, yes, matrimonial cases. Anything else? Anything else apart from these? These are very common grounds. Anything like 2, 3 harassment, Prachirati, harassment of like what? Harassment, Prachi, ma'am, can you please elaborate on this part? What kind of harassment?
Sir, am I audible?
Yes, ma'am, you are audible.
Good morning, sir.
Good morning.
Sir, by harassment, I meant that nowadays, we see that, no, obviously harassment has been there in office places and everywhere, but now people are opening about it. But sir, when I was doing an internship, I came across this case where there was a fake case filed against the boss. The only
Mhm.
reason of doing that thing was that he was not a suggestion was given by the employer and he did not entertain the suggestion because he did not feel like entertaining it. So I came
Mhm.
across this thing, and after that I did a lot of research on this. So there I find that now people are misusing it in a bad way,
Ramya Pandey,
which
very
is
rightfully.
deteriorating everything. Like, because of that, the confidence is also getting deteriorated.
Mm.
That's what I meant.
Perfect. And let me give you a few examples. I know a case. This case involved an IPS officer of UP. He got married, and because he was from Bihar, and because obviously my senior is also from Bihar, so obviously we knew a lot of internal things which the client wouldn't have told to the other advocates. It was that at the time of marriage, he got a dowry close to 15 crores. Okay, he was an IPS officer and he got a dowry close to 15 crores. But the thing was that the wife had an affair prior to the marriage, and the wife didn't wanted to marry him. But because of the family pressure that the prospective husband is the IPS officer, so she got married to him. But her affair with her former lover continued. And after the marriage, the wife said that I want to go to Delhi. I also want to prepare for UPSC. The husband was posted in UP, so he said, "Yeah, fine, go for it." And after 3 months of the marriage, she moved to Delhi, and then she never returned home. Now, finally, it was disclosed after like 6 to 7 months of constant communication, like what's happening, what's going wrong, and all. It was finally she confessed that she married him out of fear and force and fear by her family member. She never wanted to marry him, and that's the reason. So the IPS officer was like, "Yes, fine, then take a divorce. I'm going to return the 70% of the dowry which you have given to me." Okay, and he was honest on that part. And but what actually happened that considering the state and the conservative family from which she belonged, the father uh, the father of the wife, what he did that he filed a fake dowry case against the IPS officer, and the case went for like close to 4 years, and it caused a huge harassment. Obviously, I'm not denying the fact that yes, taking dowry was not wrong. Yes, he took the dowry, but that was something was given by the father because his father was like, yes, I can afford to pay that much. You know, I'm offering this much of amount of money on my own will. The reasons can be many, but the thing was that the case which was filed was you know was done in order to hide the affair of his daughter. So that is why the case was filed, so that the affair part doesn't come out. Similarly, when I started practicing, there was one case that there was a woman. She was married, and I'm not blaming that. Yes, only the women files the false cases. But the thing is, there are if we look at this thing, we can look these. Just wait, someone has message. Just give me 1 minute. Huh? So I've shared my LinkedIn ID with you, so I'll humbly request that all those people who will join, please connect with me on LinkedIn. So what actually happened that she was a married woman, and the woman had an affair with the another person who was not married, and that guy used to tell her that you are also married after a few times. Uh, uh, after few times he told that let's end this affair because we don't have any future. You are married to someone and he's well settled. Let's end this, whatever has happened. But the woman didn't wanted to end her affair. So what she did that, just like your co-participant Amrita Mohanty has said, rape cases, she filed a rape case against him. The case is still continuing in the court. Unfortunately, on the first instance, my senior, when I was assisting him, and I also drafted, and this case happened during the first lockdown. So I did my share of research work, and I found out few judgments also. So what actually happened is that we filed an anticipatory bail, and unfortunately, see what you will see in the litigation is no that in litigation, place also matters a lot. It just wait, what is happening today? Okay, so litigation places also matters. Like I knew that if we would have filed the same anticipatory bail matter in Delhi, the judge would have considered our grounds and would have granted the anticipatory bail. But considering we are filed in Gurgaon, and it is unfortunate, but it is a reality that outside Delhi or outside the metro cities, the the mentality of the judicial officers are it are subjected to two things. First, they are a bit what should I say, conventional, they are a bit conventional in nature or traditional in nature. Okay, that they're like, okay, the anticipatory bail has been filed, so what should we do? Whether should we grant bail or not? And the second thing is, it becomes very problematic for them also that if the magistrate or the sessions court, sorry, if it is a rape case, then obviously it goes to the sessions court. That if the court grants the bail, okay, that's, and if someone if the accused tries to tamper the evidence, or if he jumps the bail, means if he runs away, then his whole then his promotional aspects come at the stake. So that is where something it bothers the judges. But ultimately, after like 40 to 45 days, on the third hearing, in fact, we were able to secure regular bail for our client. And then when we see the media, when we see this news, when we see the news, what we find, when we see the news, what we find that there are a lot of cases, like very recently, Rohtak sister cases. Please note it down. Then Hasleen Kaur case, finally that person was acquitted. Okay, so all these and rightfully, Prachi ma'am has also said that misuse of the POSH Act. Then some of your friend name was Soumya Pandey ma'am told that misuse of sedition laws also. So all these laws are there which are grossly misused, and the thing is, how do we actually fight those cases? Now, before going, like I have designed my further lecture into three parts. Like in the first part, I'm going to explain that why actually, which all of the areas, apart from seditions and prevention of sexual harassment at workplace. In fact, sexual harassment at workplace also I'll throw some light. But apart, keeping aside the sedition part, because filing sedition case is not very common, or not, it's not that we see in every district or which see happening in every other day. But the false cases filed against the person is something that which we can see in each and every district. So I have planned this webinar in such a way, your next 30 minutes, that first, why these false cases are filed, how these laws are misused, what are your legal rights, and what should you actually do. And in the last part, yes, I will take your questions also. And before moving forward, of all those people who have just joined this webinar, I'll again request, I shared my LinkedIn ID with you, and I'm also sharing the link of the course which I have just launched, which is going to start from the next week. And I've shared the link of my course, and in this course I'm going to give you, it's a 6-week course, I would say, in which 12 live classes, 6 recorded sessions. Each and everything, each and every, all the important aspects of criminal law or CRPC are covered, and important aspect of CPCs are also covered. And as I have the experience of judging more than 15 competitions, I will also teach you how to draft a board court memorial. And as I have got 7 publications, I have presented 25 research papers. I will also teach you how to write a well-structured research paper and how to avoid plagiarism. So I'll humbly request that and to please go through the syllabus once. The classes are both online and offline, and also classes are all online and offline. All the classes are on weekdays, Friday, Saturday, and Sunday, and 4 p.m. onwards. So don't give me this excuse that we have our classes, we have our internships, and we have this exams. Because even if you have exams or even if you miss out any lecture, I am going to give you a recording of each and every lecture for 15 days. So for every 15 days, you will have the recordings of each and every lectures. So there are, and please also, the most important part, please compare the prices also. Price of my course with all the educators who are offering such similar courses in the market. Please, I will humbly request that please compare the prices. My course is the most cost effective. Please go through it, and also please connect with me on LinkedIn so that you can see I have taught more than 1,000 students through paid courses and more than 4,000 students through for free of cost through these kind of webinars. So please connect me on LinkedIn and please see the reviews of my students about my teaching. Okay, so now moving forward. In this webinar, I am going to take up like 5 important things. 5 important aspects where the laws are mostly misused. And it's not that the women are only misusing the laws. The thing is, if we see, doing a small recap, there are 2 aspects. At the societal level, the women are always subjected to discrimination. They are subject to harassment, and they are also subject to, like they face a lot of hurdles in every aspect of their life. Okay, but when it comes to the legal aspect, it is something that where there are some areas of the laws which has actually provided a lot of gray areas, which has provided a lot of gray areas to the women to misuse such laws, which are first dowry cases, rape cases, just like Prachi ma'am has said, sexual harassment cases, and domestic violence cases, and last but not the least, the media trial, which is being the catalyst. So I'll explain now the reasons. So now, what could be the possible reasons that why these laws are being misused? First possible reason, let's take the example of the dowry. I have given you the example of one of the cases in which I have dealt. Also, please Google the case of Nisha Sharma dowry case. It's a landmark dowry case which happened way back in 2003, and a lot of media trial happened. She was called for many interview. Even the woman Nisha Sharma, and because I know a lot of realities, because one of the cousins of Nisha, she is from Ghaziabad, and one of her cousin of Nisha Sharma was my batchmate in Pune when I was studying law. So Nisha Sharma was also invited. You won't believe it, by she was also invited by Oprah Winfrey in her talk show. And later it was found that Nisha Sharma had an affair. She didn't wanted to opt for the arranged marriage, and just to get away, she filed a false dowry case, and she filed a false cases where, and she said that her prospective in-laws are demanding huge dowry. So first, it is the covering up your own crime. First is the reason. Second reason is the vendetta. Vendetta means revenge. Like suppose there is a clash. See, in every couple, there are fights. I'm not saying that domestic violence is not an issue. I'm not denying the fact that dowry is not an issue. If we see the NCRB reports, every year more than we get a report of more than 9,000 dowry deaths in India. Means 9,000 women are murdered for dowry. So I'm not denying the fact that dowry is not a problem. And in fact, in my 7 research papers which have been published, 5 research papers are especially for the women centric. So it's not that I'm just taking the sides of just I'm just being one-sided, but it is equally important for you to have a holistic point of view of the society and to look at a particular issue from both the sides. So first, second was the vendetta. Third, like I have said that I've told you about the covering up their own crimes, and lastly, in many cases, it has been observed that when the partner, the woman feels or the wife feels that yes, now we are in the verge of divorce, we should take a divorce. So these laws, especially Section 498A and dowry laws, it acts as a biggest catalyst and biggest, I would say, the opportunity for such people to get a better deal regarding the maintenance and the alimony. That is a fact. Now, coming to the rape cases. Again, I'm not saying that rape is not a problem. Unfortunately, it is like in the land of Lakshmi, like we pray that goddess of power, Ma Durga, goddess of wealth is Ma Lakshmi, goddess of knowledge is Ma Saraswati. Okay, and so in this land, in the country where we pray women to this extent, unfortunately, India is one of the, in fact, it is the most unsafe place for women. It has become, because when we see the cases of rape cases being filed, it is close to 35,000 cases every year. And this is something like recently NCRB reports have been of 2020 has been published within 2 days. So I've not checked it, but last I remember it has already crossed 35,000 rape cases in 1 year. So we have to accept that yes, it is a bigger problem, but at the same point of time, we have to also accept that these rape laws related regarding to rape, laws regarding to domestic violence, laws regarding to dowries are most misused by the women. And do you know? And the irony is that in dowry cases, the real victim are not able to report about their cases in the police station. And if you see, if you do the legal research work, okay, you will find that 80% of the dowry cases which are actually filed in a criminal cases, 80% of the cases ends up in acquittal. So it has not today it has become nothing but a tool for what, like for a personal vendetta, for revenge. Now rape case. Now when we read about rape, section 375, it clearly says that for a sexual intercourse between a man and a woman, the consent of the woman has to be obtained. The consent has to be full and valid. Consent should be there. It means that the woman should be in a position to give her valid consent. Valid consent means that the woman knows what she is doing. The woman is giving her consent willfully. The consent is not obtained by the way of fraud. The consent is not obtained by any way of coercion or by way of any manipulation or by any fear. If the consent is obtained by fear or fraud, then also it is rape. For example, Supreme Court has, in many of its landmark judgment, has said that if sexual intercourse takes place on the false promise of marriage, then it is a rape. And these judgments are right. These judgments are right. Why? Because to understand the concept better regarding the consent, this word consent, read section 88, 89, and 90. You will understand what does the actual consent means. Consent also means that the consent was given in such a way that the woman knows the consequences of the act. The woman has the power to withdraw the consent at any point of time. But if the consent is obtained and the confidence of the woman is taken into consideration, where she feels that yes, in future the person is going to marry me, and then she gives the consent, and Later on, it was found out that the consent was only obtained for the purpose of physical intimacy, then it becomes rape. But this is the law. But at the same point of time, what actually happens? They are in relationship. See, I'm telling you the law, and I'm also standing by the judgments of the Supreme Court. But the other side of the picture is the consent is taken. Two people are in relationship. Consensual physical relation is established between the couple, and later on, due to any indifferences, because of any reason, they broke up. Okay. Then again, this is again either for the blackmailing purpose or for the personal vendettas. These laws are again misused. Why? Because in the rape cases, it is mandatory. It is mandatory for the police to register the FIR, and the medical examination will take place. Now, the medical examination, even if it's a consensual sex, it can show that the intercourse actually happened. But it becomes very difficult on the part of the man to explain that when the relation was established, that point of time it was consensual in nature, and that point of time both the consenting adults what should I say? They were in the agreement, and the things were smooth at that point of time, and things actually got distorted after a few days later. Okay, so it becomes very difficult on the part of the man, and hence it becomes a very huge ground for misuse. And it is often seen that when such cases are filed, usually in such cases, media trial takes place. Now, I will go to the what are the laws and then the possible recommendation which one should actually do. Now, before moving forward, let's analyze two important judgments. First judgment is Lalita Kumari versus State of UP. This judgment says, so this is your first remedy, that how you have to protect or how you have to fight a false a criminal case which has been filed. First judgment, it says, Lalita Kumari versus State of UP. It says that that if a person goes to the police officer, it goes to the police station, the FIR has to be registered at any cost. The police can never do what? Like refuse to register the FIR. Okay. But at the same point of time, there is one more judgment, which is Arnesh Kumar versus State of Bihar, which the judgment was given in 2014. And this judgment was precisely given from the perspective of the men, especially in the dowry cases and domestic violence cases, 498A cases. The judgment said that, yes, even if the FIR is registered, the police, it is the duty of the police to fulfill all the criteria from section 41 to section 60 of CRPC, and just to check if the police finds that in these domestic violence cases arrests are necessary or the case is genuine, only then the arrest should be made. Okay, otherwise there shall not be automatic arrest, especially when the FIR is filed under section 498. So this is the first ground, that first you should have the knowledge that what is your right and what are the laws and how the laws has been interpreted by the Supreme Court and what are the guidelines which are given by the Supreme Court. So please always remember these two important judgments. If the police does not register the FIR, you should know what are the guidelines given in the Lalita Kumari's judgment. If the police, just after registering the FIR, arrest the person, you should know what are the guidelines of Arnesh Kumar judgment. Okay. Now moving forward. So first aspect, what you can do to fight such cases. Now, when you realize that, okay, a false case has been registered against me, first thing, what will you do? Like apart from calling a good lawyer. Like, give me some suggestions and then I'll move forward. Like, next 10 minutes are very important. I'll dictate you two important judgments also. Come on, tell me. See, let's make this interactive. So this how the session will become interesting. Okay, please tell me, what will you do if you got to know that a false FIR has been registered? Apart from like calling a obviously that's it said calling a good advocate. Apart from that, what will you do? What are the precautions which you can take? Alright, give it a try at least.
Sir, there's some answers in the chat box.
Anticipatory will, Amrita, now you will not answer anything because she is my student and she is also my intern. And she has prepared all my, she had helped me in preparing and editing all my modules. Apart from Amrita. Because not only anticipatory bail is there, a lot of other things, a lot of other remedies are available. Is Tanya Swaraj there in the meeting? Because she just commented that she didn't receive the webinar link.
She is not in the meeting, sir.
No, it's all right. It's all right. Fine. I'll message her some later. Apart from anticipatory bail, because see, getting an anticipatory bail is one of the toughest job in criminal litigation. Trust me. Because you have to convince the court that why you should be given bail before the arrest. Okay. Come on, give it a try. What all remedies are available? Okay, no problem. Don't stress too much. See, first is if the anticipatory bail has been told, let's start with the anticipatory bail. Anticipatory bail means when you know that there has been police case filed against you for a cognizable offense, or for which the police can arrest you without a warrant, and you know that you have not committed a crime, but somewhere down the line you have been freed. So you go to the court, and according to the charges, you file the anticipatory bail. Okay, and you can try to convince the court that you should be given bail just before the arrest itself. You have to explain the court. Now, in the judgment, write the judgment in the Siddharth Vardharajan judgment. He was a senior associate in the news channel or the news link, The Wire. Okay, and he was given an anticipatory bail in May 2020, and that was the one judgment which I cited. Usually, the practice of anticipatory bail was that that even if the FIR is not registered, they get the anticipatory bail that yes, they can file an FIR against me. So just to prevent myself, see, these are the grounds. You have to convince the court that why, and those grounds, it is what your legal research comes into the picture, and then you take. It's very difficult, I'm telling you, okay? But you have to convince the court that, yes, on these grounds, I should be given anticipatory bail. Earlier, what used to happen that anticipatory bail, the court used to do that, yes, surrender to the court. If the anticipatory bail is not given, surrender to the court itself and take the regular bail. But now, in those judgments, now suppose the question arises that if the FIR is registered, the police is coming to arrest you, then can you take the anticipatory bail? Yes. That's on all these issues. Please, if you connect me on LinkedIn, I'll give you the judgment also. That all these issues, because it's very difficult to cover all these aspects in one go in a small webinar, okay, of a 1 hour webinar. So all these aspects were dealt in detail in Siddharth Vardharajan judgment, the latest judgment by the Supreme Court. Okay, now moving forward. And that's where I told you that in my case, when we filed the case in the Sessions Court of Gurgaon, ultimately because the charges, although we had a lot of supporting judgment, but because the charges were very serious in nature, we were denied anticipatory bail at the first instant, and it's fine. There was no point of complaining it. Then obviously the accused had surrendered, and then after a few days, we did file the regular bail. And we filed the regular bail and we got the bail. So that was not an issue. Now, Second aspect where you can protect yourself from such false cases is that please collect as many evidence as possible. Okay, please collect as many evidence as possible. The evidence can be your SMS. The evidence can be if you are talking to someone physically. The evidence can be what? The evidence can be your tape recorded conversation. The evidence can be your call recorded conversation. And you can file a cross FIR against the case which has been filed. And under which offense you will file the cross FIR? Section 191 of IPC. And that's the problem in the law schools, that in law school they start teaching IPC from section 141 to 160, and then straight away from section 295 like blasphemy laws, and then murder, culpable homicide, and all these things are taught. But what is the false evidence? What is the abatement? What is criminal conspiracy? What is general exception? What are private defense? These are some areas where the law colleges skips, or they don't go into much details. And that is where in my teaching I have always kept my courses very pocket friendly in nature, so that you can you can also submit my fees through your pocket money also, so that you don't have to tell your parents that I need 5,000 or 10,000 rupees, I have to enroll in this course. I have kept the fees in such a way that even if you can afford my fees from your pocket money. Okay, and now Chelsea has asked, sir, why is that
So there's a
punishment?
question.
Yes, I know. Why is the punishment mostly provided under IPC when the accused is convicted for the charge under IPC and POCSO? What is POCSO? Okay, fine. Don't mute yourself. Unmute yourself. See, there are many laws, and that's what when I was invited by Geeta Institute of Law, Panipat yesterday, I explained that IPC is the complete law. And there are some, no, that's not, I didn't ask it the definition. I asked, my point of asking was that why the POCSO actually came into the picture. See, we have Protection of Women from Domestic Violence Act, okay? But when the FIR is registered under Protection of Women of Domestic Violence Act, under which section the FIR is registered? It is still registered under section 498A of IPC. The punishment is given under section 498A of IPC. So what are these laws? Domestic violence laws. These are the laws which actually elaborate the women-centric problems. Why? Because when you read IPC is mostly, see, law serves three purposes. Always remember this. Punitive measures means the punishment part. Preventive measures means to frame such guidelines or laws which prevents the crime from taking place. And third is the remedial portion. IPC just deals with the punitive measures. So that is why we have supporting laws with IPC, which actually explains the problem. Like Prevention of Women from Domestic Violence Act, when you read this law now, it actually elaborates that who is a woman, what is a household, who is an aggrieved woman, what can the woman take interim relief such as compensation or maintenance in Domestic Violence Act, who is the officer who is going to conduct it, all these things. But when the punishment part comes into the picture, the FIR is registered under section 498A. Similarly, just like Prachi ma'am has told, prevention of sexual harassment at workplace. What is prevention of sexual harassment at workplace? Any workplace which has got 10 or more people, they have to keep the internal complaint committee. And internal complaint committee is what? They collect the complaint, they take the complaint, they keep it confidential, they conduct a preliminary inquiry of 90 days. They have they have a duration to conduct the inquiry of 90 days to rule out the possibilities that whether the fake case has not been filed, or if the conciliation can take place between the co-workers because they have to work at the same organization for a longer purpose. But if they feel that no, the offense was grave in nature, then again, the prevention of sexual harassment at workplace, the FIR is registered under section 354A of IPC. So I guess, Chelsea ma'am, this clears your doubt. Similarly, POXO, the punishment is given under section 376D. Like what was the CRPC amendment of 2018? CRPC amendment of 2018 said that if the woman who is less than 12 years of age, and if the woman, if that child, if the girl child is raped, then the rapist can get the death penalty. Okay, and okay, so and in which section? This is about the CRPC amendment 2018, and which section was added in IPC? Section 376D. And in section 376D, it explains everything. But now, what do we need? Why do we need POXO? POXO is where it actually explains that who is a child, what kind of offenses are more serious in nature, what kind of offenses are actually constitute sexual offenses, what kind of offenses, and in what if you read section 7 to 10, it actually elaborates and it actually gives you very elaborated definition about the sexual offenses against the children. So that is why, to give a more elaborated version of particular some particular kind of offenses, we make these laws. But again, the punitive part is always taken care of by the IPC. Okay, so now coming back to the again, which can file? Is there any time criteria? No. It's just that you have to convince the police officer that why you are coming to file an FIR at that point of time. Okay. Now, it is when you don't even tell this thing in front of your seniors. Like if seniors ask you that FIR is registered, so what should we do? Should we go for bail or should we go for the quashing of the FIR? Never say we should go for the quashing of the FIR. Always say we should go for the bail first. See how the chain goes, how the stage of the criminal case goes. First, the arrest has been done. Then always go for the bail first. First, secure the release of the victim, and once the investigation is started or it's over, then if you have additional evidence, then go to the High Court and file a petition under section 482 of CRPC for quashing of the FIR. Why? There you have to convince the High Court that a false case has been made against me. These are the evidence. Please conduct the inquiry. And after the argument, if the court feels that yes, a false case was registered, only then the High Court uses its inherent power. It uses its inherent power and quashes the FIR. Otherwise, it is not a general practice. Why? Because if High Court start quashing the FIR at a regular basis, then the job of the police will be over. The police will not be able to conduct any investigation. Okay. So now, just wait. The minimum punishment is, ma'am, please read again. The minimum punishment of rape has been amended in CRPC 2018. The minimum punishment is 10 years. And regarding the section 42, that notwithstanding anything contained in the law, 10 months before the found guilty of the sexual under this act or as provided the punishment which is greater or degree. Yes, which is so. What's wrong in section 442? I think this is right. Like whatsoever it was, the POXO was made in 2012. That time the punishment for rape was 7 years. Okay, the punishment was 7 years. So that is why to give the maximum punishment, it was said that whichever punishment is higher, that will get. And prior to 2013 amendment of criminal cases, under section 354, which talks about the molestation, the maximum punishment was or fine or both. And now after the amendment of 2013, what is the punishment? Minimum 1 year to maximum 5 years under section 354. And now after 2018 amendment, the minimum punishment is 10 years. It's okay. That is why you are attending this webinar, to learn something new, that too in the morning. And I'll humbly request that please everyone go through the syllabus of my course and connect with me on LinkedIn. Trust me, and please at least go through the syllabus once, and trust me, you will learn a lot. All the important portion of CRPCs are covered, and important portion of CPCs are also covered. Now, moving forward, if the false case if you have a tape recording and if you have a conversation recording. Then in the judgment of R.M. Malkani, please write down somewhere, R.M. Malkani versus State of Madhya Pradesh, R.M. Malkani, R.M. Malkani versus State of Madhya Pradesh, 1973 Supreme Court. It was held that the tape recorded conversation, the tape recorded, start writing. The tape recorded conversation are relevant fact, are relevant fact, and is admissible under section 7 of Indian Evidence Act. Okay. And can you please tell me one of the landmark judgment which was given in the same year, 1973? It was Keshavananda Bharati's judgment. Okay, because I have to cover up very quickly now. Now, in the judgment of second judgment, in the judgment of Ram Singh versus Colonel Ram Singh versus Colonel Ram Singh, Supreme Court, 1985. It was held that while admitting a tape recorded conversation, few things has to be taken into consideration, which are the evidence should be accurate first. Second, there should be no tampering. Third, the voice should be audible. The device in which the recording is there should be properly sealed, and the voice of the speaker should be duly identified. Means one can identify that, yes, one can easily identify that this is his voice. All these things. And now, because when the level of crime has also gone up, we take the help of the forensics now. Okay. Now 438 done, 482 done, cross FIR 154. Okay, and also you have one more remedy available to fight such false cases, is that you can file a defamation case against the person who has filed. Along with filing a cross FIR, you can also file a defamation case under section 499 of IPC. Now, lastly, suppose you have taken all these things, but the media trial has started. Now, what will you do? Because media has the right to report everything about the court proceedings. And which laws gives them this right? Exception 4 of section 499. Exception 4 of section 499. But the thing is, the media has to just report whatever is happening in the court. But what they do is that media carefully misinterpret that section and they start conducting their own parallel trial, which is media trial. Always remember, all types of media trial everywhere are unconstitutional. There is no justification for media trial. So if the media trial has started, what will you do? You'll file a defamation case against the media houses first. You will file a criminal contempt case against that media houses second. Lastly, these are what? Punitive measure. Means once the media trial has gone and it has ruined your image, then. But preventive measure is what? What will you do for as a preventive measure for the media trial? If you have looked at the syllabus, is that you will file an injunction suit. Okay. One of the cases, Sushant Singh Rajput case, we have seen how the Rhea Chakrabarti was harassed by the media, and because of the media trial. The other actress, Gurleen Kaur, and the actress, I'm forgetting the name. She worked in the movie with Ajay Devgan in Karle something, De De Pyar De. The movie's name was, I'm forgetting the name of the actress. What she did, she filed an injunction that until and unless the final order of the court is passed, the media should be refrained from anything discussing should be refrained from anything reporting about this particular matter. And that is where, again, that is your right. But again, to exercise your right, you have to convince the court that this is how my rights have been violated, and that is how the injunction should be there, given. Now, finishing in it, injunction are also of two types. Permanent injunction under Order 39, Rule 125. Permanent injunction, where permanent injunction is what? It is prohibitive in nature, where you go to the court and you ask for permanent injunction. When the court impose Rakul Preet Kaur, yes, when the court gives the permanent injunction, it asks someone to stop. Okay, it prohibits a person from doing anything. That is permanent injunction. But now media has done their trial, and 15-20 videos about you are uploaded on their YouTube channel of like Z News or Republic TV. Those videos are uploaded. Then what will you do? You will file a mandatory injunction. Mandatory injunction is where the court orders you to do something. Means when you file the injunction suit, it is a general practice that you file both permanent and mandatory injunction. Permanent, stop there, and mandatory, to do something like suppose what you have uploaded the videos, that yes, please delete those videos, and when the final order of the court is passed, you can re-upload it. But now suppose when you are drafting this thing in your internship or in your practice, and you have just drafted in the heading the permanent injunction only, then what will you do? Where is mandatory injunction? It is not mentioned in the CPC. It is mentioned in a specific relief act, section 39. Section 39. Then what will you do? Like suppose you have forgotten. You will file under CPC amendment of pleadings. Order 6, Rule 17. Very easy. You have to convince the court that yes, prior due diligence was not possible and it was a clerical mistake. We want to amend the title of our petition, and we want to amend from permanent injunction to permanent and mandatory injunction. Okay, and you have to convince the court that yes, no prejudice will be caused to the other parties. And all these things, drafting permanent injunction, mandatory injunction, amendment of pleading, is also covered in my course. So I'll humbly request you to please connect on LinkedIn and please have a look at my syllabus, the syllabus of my course, and enroll. So guys, this was your small webinar. I hope you have enjoyed it, and now I'm open to the questions. No, Chelsea, it's all right. Feel free to ask as much as possible. It's okay.
So, guys, you can drop the questions in the chat box.
So, can the punishment be provided in the? No. Punishment is just one. It's not repeated. Okay, punishment is always given in the IPC. But if the higher punishment of the same offense is is given in the any supporting law, then that punishment is opted. Okay, like suppose if the punishment for any offense is given as 8 years in IPC, and in POCSO if it's given 10 years, then the court will opt for the 10 years imprisonment. Okay, so please, I'm open to questions. Please ask your questions now. Yes, Amrita, you can unmute yourself.
Sir, good afternoon, sir.
Good afternoon, Amrita.
Sir, the question was that in case an FIR is registered, and that the person against whom the FIR is registered has given a written, in writing, he has submitted in the police station that he would not continue the action for which the FIR was registered. And after that, he somehow starts stalking the person who has submitted the FIR and starts moving around where that person resides. So, sir, what kind of preventive action should be taken?
No, second FIR then. Second FIR. What will happen is that when two subsequent cases are being filed, then the accused will have a very tough time in taking bail. Why? Because the victim can clearly show that the accused is a repeat offender. So once these things are brought into the court and the judge takes these things in cognizance, it is very difficult for the accused to get bail. Yeah. Okay.
Okay, sir. Thank you, sir.
Yeah. Any more questions?
I don't think so. There are more questions.
Yes, so it's over 1 more minute if they have. Yeah, it's 12 also. Any more question, guys? And just wait. I will drop the link of my course again. Please go through my course, and all those people who are not yet connected with me on LinkedIn, I have shared my I have shared my LinkedIn ID with you. Please connect with me on LinkedIn also. Okay. So, guys, yes, this was our small webinar, 48th. Okay, and
Uh,
I've
Thank
got
you so
like
much,
two
sir.
webinars lined up. So yeah, fine.
Thank you so much, sir, for this amazing webinar. We are grateful for the time and effort you took to share your thoughts and experience with us. So, with this, we come to the end of a very beautiful yet memorable and fruitful morning. Okay, and participants' webinar will be available on the YouTube channel, on our JustVocates YouTube channel. If the participants are willing to go through the session again, you can visit our YouTube page. Thank you so much, sir.